During the vice presidential debate, there was a discussion about the events of January 6th and President Trump's election litigation strategy during the time period of November 2020 and January 6, 2021. I want to just talk, generally speaking, about what I think the Donald Trump legal team was thinking as to why they thought and what they thought they should do in order to try to address what they considered, I'm presuming, to be shenanigans associated with the 2020 election. And I'm going to keep this at a very high level, but I want you to understand this at a general level because this is very important and there's a lot of misunderstanding out there, in part, I think, because the media doesn't want people to understand, and in others because people just don't understand this because there's some very sophisticated legal maneuverings that were going on here that I will explain to you. You will understand it, but there's, again, a lot of people out there don't want to understand this or can't understand this because, frankly, it is a little bit of sophisticated, complex litigation strategy, but you will understand all when we get right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Israel Disarmed, What the 10/7 Attacks on Israel by Hamas Teach Americans About the Right to Bear Arms. All right, folks, so this is a video I think I need to do because I want you to generally understand what the Donald Trump legal strategy was between November of 2020 and January 6th of 2021, because there's a lot of misunderstanding, I think, out there about what they were attempting to do and why they thought they could do it. Now, I was not part of the legal team, so I can't speak with personal knowledge on any of this. All I'm going to tell you is I think the overall strategy, what they were thinking and why they were thinking it, but I think this general overview will at least help you understand what the Trump team was likely trying to accomplish. Now, big picture, what I think the Trump campaign thought was that after Election Day 2020, there were shenanigans that took place in some of the swing states. And again, I don't need to go over the details of the allegations there, but there was some concern that the apparent results of the election in favor of Joe Biden were not lined up or had not either been generated properly, or there was some questions about whether or not it was accurate. Now, again, I don't have a particular view on these specific allegations. That's not the purpose of this video. What is the purpose of the video is what did the Trump team try to do in the 60 days that followed, and what were they thinking, as best as I can tell from the public record. And here's what I think was going on. Once the election day occurred and they identified what they thought were potential problems, they decided to bring a series of lawsuits. But I think what they were really focused on ultimately was what was going to happen on January 6th of 2021. Now, just to step back as a reminder, on January 6th, 2021, in Congress, Vice President Mike Pence was going to preside as the Chief Justice, if you will, as the boss, over the Congress that was tasked with certifying or not the electoral votes that were coming in from all 50 states. Now, the governing federal statute was the Electoral Count Act. Now, under the Electoral Count Act, there were some ambiguities of the role of Vice President Pence. Now, the reason why this is very important is because it seems to me that the Donald Trump strategy overall was to ultimately try to go to Vice President Mike Pence and to the Congress and argue that, look, we've had 60 days of investigation starting in early November 2020 and on January 6, 2021, and we have uncovered a sufficient amount of information, factual information, and evidence that would suggest that there was a problem with certain states in how the elections were run, and we're not sure. In our view, this is, I think, is what the argument would be, that we're not convinced that the apparent outcome in favor of Joe Biden was an accurate outcome. So, in light of what I just said, and the ultimate goal of persuading Mike Pence as the vice president overseeing the Congress, and the Congress, that something needed to be done, what exactly was the legal strategy, as best I can tell, of the Trump lawyers? Well, before we get into those specifics, I want to explain, generally speaking, how litigation works. And this is important for you to understand because you all have been following this channel for a couple years now, and we've talked about these Second Amendment cases. Now, these Second Amendment cases, as you well know, literally take how long? Years upon years upon years sometimes. These are Second Amendment cases, which in the grand scheme of things is relatively simple types of litigation compared to complex, multi-jurisdictional fraud type cases, which again is really what I think the Trump campaign was essentially engaged in, is trying to ferret out evidence of wrongdoing or fraud or problems in some way. And I think the best metaphor in terms of civil litigations is like a fraud type case, because it required a deep, intensive analysis of facts to try to figure out what the facts were, present the facts, and then apply those facts against what they thought was the relevant laws, either in the states or at the federal level or under the Electoral Count Act. Now, with that said, the reason why I think the Trump campaign thought they had the opportunity with Mike Pence is they thought there was enough question mark about how you properly read the Electoral Count Act, a federal statute, and whether or not it gave Mike Pence the authority to either ask for an audit or require an audit or reject electoral count votes or accept them or whatever it was. Now, we know that Trump had some basis for this argument, and you don't have to believe me or Donald Trump or his lawyers for this. You simply have to look at what Congress did in 2022, and that was in Congress in 2022 after 2021. What did Congress do? They amended the Electoral Count Act. Why? Because they basically agreed that there was enough ambiguity and questions about the role of the vice president under the Electoral Count Act as to whether or not the vice president could reject one group of electors and appoint another group of electors to the extent there was a dispute about which slate of electors should be accepted. Now, of course, Mike Pence did not go along with the theory that says he had that authority, but there was enough question mark that he may have had that authority had he acted on it, but he didn't act on it. But of course, in November 2022, or just in November 2020, presumably the Trump team and probably Mike Pence himself wasn't aware, had no final conclusion as to what they were going to do or not do in January 6, 2021. Because remember, they're looking down the chessboard. Put yourself back in November 2020. Now, let's go back in time again to early November 2020, where there was concerns, obviously on the part of the Trump campaign, that there may have been problems. Now, you know and I know from this channel that lawsuits often take years to go from womb to tomb, from the start of the case to the end of the case. At the beginning of the case, you make allegations in good faith, and then what usually happens is over a period of years, you literally you take depositions, you get factual documents, you do an investigation, and over a period of years, you look into the facts that underlie your case. And sometimes your allegations in the complaint turn out to be false, because when you look into the case, you realize that your allegations are not accurate. Sometimes your allegations in your civil complaint, or your criminal complaint for that matter, can turn out to be true. Sometimes they're true, sometimes they're false, sometimes it's unclear, and that's why you go to a fact finder like a jury or a judge to make determinations of facts when there's a debate over the facts. Now, the reason why that I mentioned this time period of multiple years for like an ordinary Second Amendment case is, think about what the Trump lawyers had to do here. They did not have multiple years. They knew that anything and everything they possibly could do or would normally do over a period of a multiple year litigation, they only had about 60 days. Hear what I just said? The multiple years that often takes place with a civil litigation, and Second Amendment cases are very simple compared to like multi-jurisdictional other civil cases in other contexts. They had 60 days. So they were working under a very, very tight timeline here. Now, why is that so important? Because there was two parallel path things that the Trump lawyers and Donald Trump's team had to do. They had a parallel path to things. And this is going to get into that issue involving the allegations associated with these alternative electors, or these alternative slate of electors from these various states. Okay, parallel path. What was the parallel path? If you're a lawyer for Donald Trump and you're trying to sort of argue that there was a problem in a particular state, and therefore the electors appointed by the governor of that state should not be the one accepted by Congress, the alternative slate of electors should be accepted by Congress other than the one that the government signed off on and sent in to the Congress. What do you have to do? Well, again, there's two things, and they had to happen simultaneously, which goes back to the fact that something that takes many years in the normal context, there was only 60 days. And during that 60 days, you also had to deal with holidays like Thanksgiving and, of course, Christmas and New Year. So you even had, in many respects, less than 2 months, given the fact of when it occurred during the calendar year. So the two parallel paths were there had to be essentially the lawyers had to go out and find or show some sort of liability, if you will, some sort of a problem. They had to establish that these elections or one or more of these elections in these swing states were somehow flawed in some material way. Now, there's a bunch of different arguments and theories as to why that was good or bad or ugly. It doesn't matter. Not the purpose of this video to get into the details of any of these cases. That's beyond the scope of this video. All I'm saying is the Trump lawyers realized they had to go to these states and they had to basically expedite and try to find evidence that there was a problem in these states without the benefit of most cases, which go on for multiple years, where you're given literally like 2 years to try to prove your case. The Trump team did not have 2 years. Why? Because they only had 60 days, because everything was going to happen on January 6, 2021, the good and the bad and the ugly. So that's all they had, 2 months, to show there was a problem in one or more of these states. Now, at the same time, they also had another major thing they had to do, which is to address the proper remedy. Now, we've talked about on this channel the importance of understanding the merits of the case and the remedies. In the context of the Second Amendment, the merits of the case are, what does the Second Amendment mean and how does it apply to a modern gun control law as to whether or not it's constitutional or not? That's the merits of the case. But we also talk about procedure, the process, the way a case moves womb to tomb through the court system. And that often ultimately gives rise to the remedy. And the remedy is, what do you want the court to do at the end of your case? So on the merits of the Second Amendment, for example, and then we'll tie it into this Trump issue, for the merits of a Second Amendment, you want to say that, for example, 18 and 19 and 20-year-olds under the Second Amendment have a right to keep and bear arms. And therefore, a state law that says 18, 19, and 20-year-olds cannot buy guns in that state violates the Second Amendment. That's the merits argument that says there's a violation of a constitutional right there. So now what? Then, once you've established that, what happens next? We know what happens next. You turn to the proper remedy. The remedy. But the remedy is what do you want the court to do? Or the jury to do? And a remedies could be anything from, okay, I've now been injured. I want the jury and or the judge to give me the remedy of giving me money. Or I want the judge and or the jury to enter the remedy of an injunction, a permanent injunction that says that the state can never enforce that law that says 18, 19, and 20-year-olds can't buy guns, let's say. I want a permanent injunction as my remedy that says they will never enforce that again. Okay? Those are the kinds of things. You've got the merits, and then you got the remedy. Now, the reason why I want you to understand that distinction is that the Trump legal team had to basically be pursuing both at the same time. Simultaneously, they had to argue that, or try to show factually in a period of no time, that there was a problem, a legal problem, a factual problem in one or more of these swing states. And at the same time, they had to figure out what is the proper remedy. Now, since this was really about who won the presidential election, monetary damages was not a remedy that they were seeking, nor was some sort of particular injunction per se. What they really were seeking is that they wanted an alternative slate of electors that were going to vote for Donald Trump to be the slate of electors that the Congress approved. They wanted the slate of Biden electors from a particular state to be rejected by the Congress, and the Trump slate of electors to be accepted by Congress. That was the argument. Now, there's a long-standing analogy that comes from the world of corporate directors, and we're going to step back and then tie it back into Trump. There are often cases when you're dealing with companies where you have fights over the board of directors. Who sits on the board of directors of a company can be really important. Let's say, for example, you have a fight between one group of directors and another group of directors. One group of directors wants to, for example, sell the company to somebody else or merge the company and get rid of the company. The other group of directors doesn't want to merge, doesn't want to sell the company. They want to keep running the company. So then you turn to the shareholders, and the shareholders will vote. And what they're going to vote for is a slate of electors. They may vote for the slate of electors that wants to sell the company, or they might vote for the slate of electors that wants to not sell the company. And that will be up to the shareholders to pick the slate of electors, and whoever is elected will be on the board of that company and will dictate the future of the company. So what the Trump lawyers, I think, were trying to do was use that metaphor and say, look, We think that the Biden directors or the Biden slate of electors is not appropriate. We think these other slate of electors is more appropriate based on the evidence we're uncovering in that particular state. And then the argument, of course, again, step back and remember what we're trying to do here. If you're on the Trump team, you want to show there's a problem in a particular state, and then you want to show that the remedy, once that problem is established and proven to be true, you want to then show that the proper remedy for that problem in that particular state is for Congress to say, we're going to pick the Trump electors, the Trump slate of electors, and that's who we're going to choose to be the electors of that disputed state. And we're going to reject this electors from that state because there was a problem that we've uncovered and have established. And that's why we're going to pick the one slate of electors over the other. So in the end, of course, we know what happened, that Mike Pence decided that he thought so he says, the proper interpretation of the federal Electoral Count Act denied him, as the vice president presiding over the Congress, the authority to pick and choose the proper slate of electors. And as a consequence of that decision and the decision of Congress to do what they did, they accepted the various slates of electors that were submitted by the 50 states. So those governors of the states that signed off on and the states that signed off on the Biden slates of electors for those particular states were accepted as valid and correct. And likewise, those states that voted in favor of Donald Trump and submitted electors in favor of Donald Trump, signed off on Donald Trump. And at the end of the day, Joe Biden had more electoral votes approved by the Congress than did Donald Trump. And because Joe Biden's numbers exceeded the number of 270, he became the next president of the United States. Now, there's only one additional point I think you need to understand as you assess the litigation strategy, the legal fights that were going on during that window of time. I think there's two general observations. Number one, there's a real question as to whether or not any of the courts had authority to really pick and choose these slates of electors versus Congress, because there is a constitutional question of whether or not the Congress gets to decide or the courts. And when you deal with something that's this political, meaning an election, it is often the case that the courts don't like to get involved. They kind of view this as what's known as a political question, which says, well, even if there's a constitutional issue here, we, the courts, are not institutionally capable of making this decision. We really think this is up to the political branches, either the states and or the Congress. So in light of that, I think a lot of the courts said this is just not a fight for us. Then, of course, a lot of the courts thought that there was no standing, meaning that the people who brought the lawsuits lacked the standing to challenge the results of the slate of electors in a particular state. So a lot of these cases were dismissed for lack of standing. And as we've talked about in other videos, if there's a lack of standing, if there's a lack of standing on the part of the plaintiffs bringing the case, they can be thrown out of court because under Article 3 of the U.S. Constitution, that means there's no case or controversy, and federal courts only have jurisdiction over what are known as cases or controversies. So that probably explains some of this as well. And again, the purpose of this video is not to say who's right or who's wrong or what's going on or anything like that. I'm not about relitigating any of these issues from that time period. All I wanted you to understand is some of the institutional thinking that I think was going on as these cases were winding their way sort of through the courts as well as through the political process, and why I think at the end of the day, the proper strategy of the Trump campaign, and I think they basically embraced this at the end, was to go to Congress and say, look, we've uncovered some problems. We haven't had years to litigate this because we just don't have the time, and you have to make a decision, and this is what we found, and we think that you, Congress, should put a pause on approving this election until you, Congress, have investigated the facts and tried to get to the bottom of some of these states. Obviously, the Congress and Mike Pence rejected those theories and certified the election in favor of Joe Biden. The last point I just want to make about allegations of fraud. Now, whatever you think, the good and the bad and the ugly, and again, I'm not getting into the details here. I don't want to learn them. I don't want to figure it out. It's just not worth our time. We want to move forward, and I do other things beyond this. This is just to help you generally understand the thinking. That is on the issue of fraud. Now, it seems to me that up until the time Congress signs off on the proper slate of electors, there was a question as to which was the proper slate of electors. And fraud usually involves some level of deception and lying and duping somebody else. And what I mean by that is, if I say this is a 1 pound gold bar and it's actually tungsten, guess what? I'm lying to you to get you to accept and pay me for a gold bar that's not gold, and therefore I'm duping you. I'm committing fraud against you. But But it seems to me, just conceptually and look and feel wise, that where was the fraud when it came to President Trump and his legal team, where they're literally telling the American public exactly what they're doing, exactly why they're doing. They're saying, look, this is our thinking. We think there were problems in some states. We want to be able to litigate this. We want there to be an investigation. We want there to be findings of fact. And we want to assess whether or not these results are accurate and correct and whatnot. And that is literally what they were saying in the news every day. And they're saying, we're going to propose an alternative slate of electors because we think that the proper slate of electors is not the one that the governors are certifying and sending to Congress. And all of this was done in the open. They were disclosing what their strategy was and why they were doing it. And again, it seems to me that until Congress approves a slate of electors, you can have alternative slates of electors in the same way that you can have competing slates of members of the board of directors in a board fight about who is going to take over the organization, this slate of potential directors or that slate of potential directors. And likewise, it seems to me that whether or not it was the Trump slate of alleged electors or the Biden slate of alleged or purported electors, that ultimately was up to Congress to decide, and Congress decided to go with the Biden folks. But until January 6th, it's not clear that people knew legally who was the proper slate of electors and who should be the slate of electors. There was a lot of open legal questions there. And again, had Trump not proposed alternative slates of electors, then there'd have been no remedy available to Trump, even if on January 6th, the Congress concluded that some of these states had engaged in mischief, or there was a problem, or there were some errors, or whatever it was, whatever would cause the flaw in that electoral system of that particular jurisdiction, whatever that was, there had to be a remedy that Congress could award. And if you did not propose an alternative slate of electors, there'd have been no remedy to say, well, we want the other slate of electors. Well, there is no slate of electors. Therefore, guess what? Trump would have automatically lose. So he almost had no choice but to come forth and propose an alternative slate of electors, because otherwise there would have been no available remedy. And as I mentioned to you, this is not something that took place over a period of multiple years, which is the length of time ordinary lawsuits and litigations occur in. This literally all had to occur in a matter of 2 months. That is beyond incredibly fast in terms of something this complicated. And again, hopefully this helps you understand the concepts that were going into this fight. And I'm not doing this to relitigate the 2020 election. That's water under the bridge. But again, on this channel, I want you to be the smartest person in the room when it comes to lawsuits and litigation. And because this sometimes pops up in the media, the Donald Trump litigation strategy, I wanted you to at least conceptually, at a 30,000-foot level, understand, I think, the big picture thinking that was going into this. Rightly, wrongly, good, bad, ugly, you can have this debate. I'm not here to judge on any of that. That's not why I'm here. But you do need to understand at least the thinking that went into a lot of this, as best I can tell from the public record. All right, folks, well, hope you learned something here today. Make sure you subscribe. Don't forget to follow me on X at 4 Boxes Diner, and we will see you again very soon, I hope, here at the 4 Boxes Diner.
Orders up. Table 2A.